Thank you so much for taking the time. I had announced that today I want to have a short, just a short workshop with some people who are interested about the basics of Austrian employment law. Why do I want to do that? Because just from my personal experience, I see a lot of people who come here to Austria, and they're like, if you are fluent in German, there is ample information about Austrian employment law available on the internet. But unfortunately, all of these resources are often only exclusively available in German and not in English. That's why I thought, like, okay, I have time this week. I just want to share some insights with people who are interested. Okay, let's dive right into it. And also, at any time, if you have questions, please do not hesitate to just interject, ask me something. I also want to know from your personal practice, like if you say, that's strange. You say something should be done in a certain way, but in my company, for instance, I know we always do it a different way. We can discuss it if you like. I'll just follow along. I have a couple of slides here, PowerPoint slides prepared, and I hope that some of it will be interesting to you. You may already know all of that, then in that case, it's only a refresher. If not, then at least you have something that, at least I hope that you will take something away from this. Okay, let's dive into it. Basics of Austrian employment law. Next slide. Just a disclaimer, because I'm an attorney. This is just for educational purposes only. This cannot be a substitute for tailor-made legal advice just for you. So just this is meant to give you an insight. So who am I? I guess most of you know some of the things I share on LinkedIn. I'm an attorney in Austria. I do employment law, I do immigration law, I do data protection, I do IP. I have founded my own firm in 2019. It's called Law and Beyond. That's why I have this beautiful logo on the top right of these slides. And I also lecture in German and in English for some of the Austrian universities, most notably the Danube University in Krems. So when I want to talk about employment today and employment law, so the question would always be like, what is this thing that we're talking about? Like, what is this employment relationship? Because there are different rules that pertain to somebody who is working in a self-employed position as opposed to a real employed position. So like just the minimum characteristics, what the mutual rights and obligations would be under an employment relationship. So that would really say, okay, this is an employment relationship where the Austrian employment laws would pertain to, and not only the general civil law rules that will also be covering, let's say, self-employed relationships. So we have two parties in an employment relationship. On one hand, we have the employee, and on the other hand, it's the organization of the employer or the employer, him or herself. So the employee has to provide time and effort to the employer and the employer's organization. On the other hand, the employer will then pay a salary and also offer some security, job security to the employee. Why do I say some security? Because I mean, it used to be, okay, you had a job, you entered the employ of a company when you were 18, 19, 20, 21, 22, 23 after university, and then you stayed with the same company for, 40 years, 35 years until you went into retirement. And that is often not the case anymore. So many people switch. And also it's the possibility, of course, that the employer says, well, I'm sorry, but I cannot keep you on. And in that case, of course, there's not as much job security as you would have liked. But those like time and effort in one direction and salary and some security in the other direction, those are just like the main mutual obligations and rights of the employer and the employee. There are also like ancillary rights and obligations. So you have a mutual duty of care. The employer has to provide, like the duty of care of the employer is, for instance, that he or she has to provide a safe working environment. And there are also Austrian rules that will provide for what it is, what constitutes a safe work environment. We might still touch that later on, but just as a preview, that would be something like, okay, you should not work somewhere where it's hazardous. There should not be toxic gases. You should not be exposed to heat and excessive noise, for instance. All of these things, there are rules in Austria in place to provide that the employer has to provide a safe work environment. On the other hand, the employee also has ancillary obligations. In his or her case, this is also a duty of care, for instance, to keep company secrets confidential. So it would not be great if you, as an employee, learn something about the newest projects that your employer had, something that this employer has worked on for the next 5 years. I don't know, a special code for a new software that was developed, and you just turn around and go to the next employer and say, well, if you hire me, I have all those plans for the next 5 years from your competitor. Why don't you hire me and give me an extra salary, and then all of this information will be yours. So you also have a duty of care as an employee. Just an initial insight about what Austrian labor law is, and what some of the ground rules of Austrian employment and labor law would be. So for instance, there's no statutory minimum wage in Austria. So there's not like something that covers each and every industry. But what we have is that in Austria, we have almost 90% of all employment relationships are covered by a collective bargaining agreement. What is a collective bargaining agreement? So you can imagine you have the employer and the employee, and between them there's a contract. But then there are certain things that would affect not only this one employee and this one employer, but all the employment relationships of a certain industry, let's say the automotive industry. So representatives of employers, and let's say it's the Chamber of Commerce in Austria as representatives, get together with the representatives of the employee side. So normally that would be the unions in Austria, and they sit down normally at the beginning of a year and hash out certain kinks where they say, well, there are new rules, let's say in the automotive industry, how many hours somebody has to work at a conveyor belt without this being excessive, and all of these rules shall be uniform for this specific industry. Or something like, what is a minimum wage? So normally the representatives of the employment side and the employee side, they will get together at the beginning of a year, or at least in the first quarter of a year, and say, okay, you know what? Life in Austria has become much more expensive. Inflation is rising. And that's why we have to adjust the minimum wages in this industry. It's not, as I said before, it's not for the entirety of Austria, but it's just for one specific industry. They get together and they have a general agreement, and these general agreements are called the collective bargaining agreements. And those collective bargaining agreements, they will then apply to each and every single employment relationship of a person who works at a company that is in this specific industry. In my example, let's say all the employees in the automotive industry. Then we also have rules on working time. So it's not, we cannot say, okay, you know what, I want you to work 80, 90 hours per week. And also normally if somebody works more than 40 hours per week, so like in general, we have a law in Austria, it's like the Working Time Act that says the normal average working hours is 40 hours per week. If you have to work more than that, that would be considered overtime. And if you have to work overtime, then this will incur a 50% wage increase. So if your employer said, okay, we need you to work more than we had agreed on, that is fine. I mean, of course, in certain limits. Again, I said it's not possible to tell somebody, we want you to work 70, 80, 90 hours per week. But let's say it is still within something that is acceptable. If your employer wants you to work more than 40 hours, that is fine, but then he or she has to pay you more, 50% more. Or it would also be possible to agree that if you work extra time, that your employer could also say, you know what, okay, we will not pay you extra for those hours that you have performed on top, but we will give you extra time off. And if you give somebody extra time off, so it will also incur a 50% increase. So that means if you've worked 1 hour of overtime, you will also be entitled to 1.5 hours of extra time off. So that is something that will also be possible in Austrian relationships. I said before that the representatives of the employees and the employers get together and just hash out problems that they foresee in their industries. That also leads to almost a total absence of strikes and lockouts in Austria. So there's normally it is the worst thing that could happen is that the representatives of, let's say, the employees in one industry, that they threaten that they will go on strike, but they hardly ever really go through with it. They don't necessarily have to do it because we have this system where the representatives get together and they try to already abolish any roadblocks on the way to a amicable employment relationship beforehand, so nobody has to go on strikes. And also another thing is, if, for instance, you worked at one business and this business was sold to another company, say you work for company A and company B then buys company A, and or maybe company B buys, like, let's say, the most important machines, and you are the person, you're the engineer who's just trained, you're the one person who only knows in Austria how to work this machine, and company B also buys, I don't know, maybe like the customer base of company A. So if the most important things are bought from your employer by another company, it means that you may also have to switch over to the new employer. So if company B has bought the most important things of company A and you've been working with company A, then you will also, your employment relationship will move over. There will be a transfer of business and your new employer will also be company B. And there are also rules in place to make sure that you do not have to suffer as an employee, that you will also not be discriminated against as an employee, because they're saying, now we have all this baggage, these old workers from company A that we never really wanted. We'll just give them really terrible contracts and we'll hope they'll leave all by themselves, or you know what, we'll just take them on and then we'll fire them right away. All of these things, of course, there are safeguards in place to prevent it. Okay, just as a recap, I just dove a little bit into what employment relationships are really about in Austria. So why, or what are those relationships where we say, okay, actually this is where Austrian labor law comes in, and as opposed to normal general civil law. So normally where you work for somebody else and you provide time and effort for this person, and this person in return pays you for your time and effort, and also provides certain job security. And then also I just quickly covered that there are no like general statutory minimum wages in Austria that cover all industries, but it's normally industry specific. Per industry there may be agreements between the representatives of the employees and the employers getting together to hash out any problems that they may have in order to prevent strikes and lockouts. Moving on. So when I said before, Austrian employment law only, like employment law only applies where we have employees as opposed to self-employed people. So what do I mean when I talk about an employee? What are some of the characteristics here on the right side? So as an employee, you would be required to follow orders, for instance, regarding your working hours, your place of work. You're also subject to the monitoring and supervision while you're at work. So you're subjugated to the organization of somebody else. You would also be provided with the equipment that you need. So for instance, now everybody works in home office. So it should be that your employer provides you with, I don't know, a computer screen, a mouse, a keyboard, like everything that you need in order to do your job. Maybe also covers some of your internet costs. So that is normal for an employment relationship, that the equipment that you may need will be provided by the employer. And you're also normally, as a real employee, you would depend on one employer. So you work for them for 40 hours per week or 38.5 hours per week. And that in Austria, as I said before, that is considered like full-time employment. And that's why like all the rules are geared towards somebody who only works for one employer all of their working week. And it's also, as an employee, you are required to work, like to perform the work yourself. You're not allowed to just tell somebody else like, well, actually today I don't feel like going to work. Why don't you cover for me? As a real employee, you don't have a right to get a substitute. You have to perform yourself. But you do not owe a specific work product. So it's not your boss cannot always say, well, I didn't like this, I will not pay you this week. I don't know, you had to hand in a report and this report was full of mistakes. I didn't like the work product that you provided, and that's why this week I'm not going to pay you. That is not what is normally the case with an employment relationship. As I said before, as an employee, you owe the diligent performance of your services. You have to make an effort, but you do not owe a specific work product. If we switch over to the other side here, if on the other hand, if you were a self-employed person, so your work is self-determined, you're free of direction and control of somebody else, you can determine more or less when you work and from where you work. You normally have your own equipment, and you're also not bound to one client. For instance, I'm a self-employed person as an attorney. I will have several clients. Like today, client one calls me up and says, okay, you know what, I need assistance with an employment contract, for instance. And then client B calls me up and says, you know what, I need assistance in data protection. Somebody has misused my personal data. All of these things, I have several clients all the time. Whereas if I were an employee, I would only have one employer. And of course, I have the possibility to use substitutes. So I could also say, well, dear client, you have a court case that was pending in a court, I don't know, at the other side of Austria. And rather than me traveling there and I have to give you a bill for all the travel time that I will incur, how about that? I will find another attorney whom I will brief. I will give them the necessary input so they can perform in my stead. So they can do all the stuff that I would have done for you. They will do it, and then either you pay me and I pay them, or you pay them directly. So I have the possibility to get a substitute. But on the other hand, I also owe the delivery of a specific work product. So if you come to me and tell me, you know what, I want you to represent me in for instance, a court case against my employer, I could not just say, well, okay, I tried my best. Okay, it was, I disregarded like most of the most prominent case law in this area, but still I tried my best. No, because I have to deliver a specific product. I have to represent you to the best of my abilities, and I also have to use whatever is expected of a diligent attorney in this case. So I would of course also have to know the newest case law. Whereas if I were just an employee, then yeah, maybe maybe I know a lot of stuff, or I just tried my best and still I would have to be paid. Whereas as an attorney, if I don't do my job, you don't have to pay me. And then there's like a further distinction. Sometimes you hear that like Austria or a lot of companies in Austria, they don't really want to hire you as a proper employee, but you're also not really a self-employed person. There's like something in between. I normally call them down here quasi self-employed people or quasi freelancers. So they have their own equipment, but they're also depending economically on one employer. And so it's a little weird. So we have like real employees, real self-employed people, and then we have something in the middle. And that is just something I just wanted to put it out there, because sometimes employers are pushing to have you as one of these people as a freelancer, and some of the rules of employment law will then apply, but other rules also of self-employed people will apply. So normally my personal recommendation would be try to be either or and not the thing in the middle, because that can sometimes become quite messy.